Last week, upon hearing of a previously undisclosed relationship, perhaps, between defense counsel and the ARCA witnesses, I took a recess here. We suspended. I had heard about email communication, detailed communication, memorializing a conversation regarding an engagement letter and a promise of retainer on March 20th and 22nd of last year, roughly 2 months before the ARCA witnesses testified. There is another email that was 2 days before the trial and after the voir dire, 2 days before the trial with a list of cases. The Sunday before the witness testified, there's a proposed script of questions and answers and suggestions. And after the trial, there is an invoice or a bill, not just for reimbursement of travel and expenses, but for trial prep. Clearly, the ARCA witnesses were expecting to get paid. So the Commonwealth, so I suspended for 3 reasons. The Commonwealth raised questions of candor with counsel in the court regarding the Rule 14 obligations. And frankly, I didn't think it was fair to have defense counsel stand up and have to answer to that without the opportunity to reflect, to talk to each other, to look at transcripts, to consult with people, and that it made sense to give you some time to do all of that, because what the Commonwealth raised does raise serious issues, not just the rights of counsel, but Ms. Reed's right to a fair trial and all that that entails. So it made sense to me to suspend first and foremost for that reason, so counsel can be prepared to make any comments if you choose to. Second reason is what the Commonwealth told us is inconsistent with my memory. So I wanted to make sure that my memory was right. So in a way to do that, I went back and reviewed the transcripts again. I started with the June 10th transcript of the discussion with Ms. Giannetti, where I raised my skepticism about defense counsel in a murder case calling not 1, but potentially 3 witnesses that you never talked to. I looked back at the June 18th voir dire hearing, the June 24th trial testimony of the ARCA witnesses, and the June 25th closing arguments of counsel. So after reviewing that, and my memory was pretty good about that. But what concerned me most is the memory that I had of a discussion here at Sidebar on February 6th, so 3 weeks ago, not last June, outside the hearing of everybody in this courtroom. And at the time, I was operating under the assumption that counsel was unable to provide the Rule 14 discovery because of a federal protective order. And the discussion at Sidebar clearly revealed that, and counsel did nothing to disabuse me of that. So I asked the trial court to expedite a hearing, a transcript of that hearing. Mr. McDermott's going to mark it as evidence. And at that point, Mr. Jackson, when you didn't answer me at first, but when you did, you said, I can tell you this. The Commonwealth is saying, pursuant to Rule 14, and you know, exclusion and preclusion of a witness is a punitive sanction for Rule 14 violations. Ms. Reed has not violated anything. Why should she be penalized when the Commonwealth has the exact same batch of information that we have about these witnesses? So I don't have any more information. I don't have any additional discovery. I didn't hire them. I didn't ask them to engage in additional protocols. So I've got nothing else to give Mr. Brennan. He's got the same information I got, and he got it at the same time. So that was concerning to me. Jim, do you have a copy of that there that you can? And I made sure, so the transcript is of the entire hearing because I don't want anyone to think anything's out of context. So we will mark that as an exhibit. And the third reason I paused is because, frankly, I needed time to reflect. I don't know what may flow from this. Obviously, I have to make findings, whatever they may be. But I wanted to explain why we recessed. I sent that one-page notification out last week about what we would be discussing. So I will hear from defense counsel if you want me to hear from you. If you don't want to say anything, that's fine too. But if you want to be heard, I will hear from defense counsel.